On this next session, we're going to be talking about the legal aspects of innovation transfer. We're very fortunate to have a practitioner join us, Philip Mendes from Innovation Law. And worth noting, I guess, in the legal profession, like many others, that one lawyer is not quite the same as the other in terms of their expertise and specialties. There's a number of different areas of law. And Philip in particular focuses on intellectual property law and related areas of law, which in itself is quite a specialist part of the law. Philip's one of only really a small number in Australia that do that at a particular senior level in a very dedicated way. So very lucky to have him here to talk to us. Philip will run through a whole range of different aspects that'll be worthwhile considering. But again, as I mentioned at the start of the day, I'm sure Philip won't mind us treating this very informally. Ask questions as we go. We've got about an hour and 10 minutes set aside for it, but it will go very quickly as there's a lot to work through. But please do feel free to put up your hand as you go, and we'll try to leave a couple of minutes for questions at the end as well. Philip's been good enough to offer to stay on just briefly afterwards to join us for lunch. So anything that you don't quite get the opportunity to talk about in the session, I'm sure he wouldn't mind having a formal chat with you as and if time permits afterwards. So without any further ado, we'll all welcome Philip.
Thank you, Brent. Good morning, everyone. Let me reinforce something that Brent said. Please do put your hand up when you've got a comment or an observation or an experience that you've got or a question that you've got. The best time for us to deal with that is when the slide's up there. That's when it's going to be most beneficial to deal with whatever your comment or your question is, and for us to explore what the implications of whatever the question or comment is, rather than at the end where it won't quite have exactly the same energy. It also means that while we're going through the slides, those things that are of interest to you are those things that we'll end up focusing more on. Those things that are of less interest to you, then we'll obviously go through those a little bit faster than otherwise. So please do raise your hand, make a comment, tell us an experience, ask a question, whatever the case might be. We could talk about a lot of stuff. This topic, commercialisation, is a big topic. In the very short time we've got, we're going to focus on a couple of things that would be useful for you to have an awareness about. I'm going to talk very briefly about what confidential information is. Confidentiality agreements that facilitate people sharing information that has value. Material transfer agreements, which are not unlike confidentiality agreements, but they go one step further. In addition to information being shared, there's also a sharing of something tangible, some tangible material. It could be a biological material, it could be physical sciences material. It could even be software. You're sharing something other than just simple information. One of the most misunderstood traps in commercialisation or implications of joint ownership of IP. So we'll spend a bit of time talking about joint ownership as well. And then a subject that I'm sure is, to most of you, something you think about from time to time, and that is the ownership of IP by students. And you will be asked from time to time, if you're involved in certain types of projects, to deal with the IP that you own by assigning it to QUT. So we're going to talk about why that's the case and how that's done and how it's gone about. So that's an outline of how we're going to spend the next hour or so. But as I say, question, comment, observation, experience. If you don't agree with me, that's okay. You can put your hand up and say you don't agree. We'll have an interesting discussion. Let's start, see how we go. What is confidential information? Confidential information is any sort of information that has the character that it's secret. Few people know about it. Because few people know about it, it has value. It's secret, and its secrecy is what gives it its value. If everybody knew about it, of course, then it wouldn't be valuable anymore. It would just be in the public domain, and it would lose that value. And that's because it has that value, because it's secret. There's a need to manage that confidential information in some way. We could be talking about any sort of IP, any sort of intellectual property or invention. If we invent something, it's confidential information right up to the time that a patent is published, and that can be years after it's been created. So we talk about intellectual property and patents as if they are property, but in fact they're not property until years after. You file a patent application, and you don't do that immediately after making an invention. You file it, a period of time elapses before that patent application may become an international application, before the application is then, before you then choose which countries to pursue your application in, before the application is examined, before the grant is actually made. That could be a period of 3, 4, 5, 6, 7 years. Well, between the time of the invention being made and that 5, 6, 7 years, it's confidential information. A lot of it may cease to be confidential because the patent application is published, but even then, between the time of the invention and the time of the publication of the patent, it's confidential information. And of course, not everything that's published in the patent is going to put everything in the public domain, because there will always be something that isn't in the public domain by the publication of a patent. So confidential information really is at the core of tech transfer. It's at the core of what we need to protect, and it's at the core of commercialisation. When you think in terms of every invention, every patent application, before it becomes property, is only confidential information, therefore can only be protected as confidential information. So it's therefore extremely important that confidential information be protected. But of course, more than inventions, trade secrets, processes, manufacturing know-how, the formulation of something, the methodology for going about doing something, all of these things, broadly, know-how, trade secrets, they're all confidential information as well. Anything at all that is information, that is known by a few, and it has value, is going to be confidential information. An idea, a concept, obviously an invention, method, methodology, formulation, composition of matter, all of these things. In fact, it's pretty hard to try to identify something that isn't confidential information. When we think about the space that we're all in, it's very hard to think about something that isn't confidential information. Beyond, just to finish that little point off, beyond science, of course, there's lots of other things that are confidential information: business information, financial information, marketing strategies, marketing processes, marketing strategies, business plans. In other words, non-technical, non-science information, but nevertheless information that relates to a business or relates to a university or relates to a technology. All of that information can also be, or is also, confidential information, is protected in exactly the same way. So confidentiality agreements are extremely important. We'll talk about what the fundamental aspects of a confidential agreement are. Unfortunately, it's a document that from time to time does need to be looked at very carefully. You would hope that a confidentiality agreement is a relatively simple document that doesn't lead to much anxiety or angst or the stressing of relationships, but unfortunately from time to time a confidentiality agreement deals in some way with something in a less than optimal way, and therefore it's never a case where you just blindly sign a confidentiality agreement. And from time to time, as researchers, you're going to be presented with that possibility when somebody presents a confidentiality agreement to you. And there's certain things about that type of document you need to have awareness of. What's the purpose of the document? The purpose of a confidentiality agreement is that it enables a disclosure of information from one person to another to fulfill whatever purpose they're wanting to achieve by that disclosure. It could be because there's a research opportunity that needs to be explored. It could be because there's a prospect of a license to be explored or a business opportunity to be explored. We want to make disclosure of confidential information, but we need to protect its secrecy. We don't want the person to whom we make the disclosure to then go and share that information with other people. That's what we need to be able to prevent. Very importantly, we also need to ensure that the disclosure of that information is not going to prejudice the ability to protect the IP. Back to our invention example, if we have a patentable invention and we disclose it to somebody on a non-confidential basis, then doing so destroys the novelty of the invention and you become ineligible to get a patent over it. So this is one of the main purposes of the confidentiality agreement, is to ensure that you maintain the ability to protect the invention by a patent. If you don't have a confidentiality agreement, you don't have these obligations of confidentiality, the novelty of the patent is destroyed, you can't get a patent. So extremely important there be a confidentiality agreement in those circumstances. It protects information that is going to be disclosed and shared with somebody else. Material transfer agreement, as I said earlier, not dissimilar to a confidentiality agreement. It protects the information that's disclosed that relates to the tangible material that's provided, but it also is going to regulate what the recipient of that material is able to do with it, what they can and can't do with it, the purpose for which they can use it. So some of the examples that we mentioned earlier: research opportunity, a license opportunity, a business opportunity, software code, any information that might be contained in a patent application. All of these things might be the sort of thing that need to be disclosed, and we want to protect it. So what's the agreement going to say? Well, the fundamental things it's going to say is one person is going to disclose, the other person is going to receive that information. The recipient of the information must keep it secret, can't disclose it to anyone else. They can use it for the purpose that's identified. They can't use it for any other purpose. And of course, these things can be one way, where one person makes a disclosure to the other, or they can be two way, where each person makes a disclosure to each other person. So it's a two-way confidentiality. Very commonly, the agreement talks about the purpose that the information can be put to by the recipient, which could be, for example, to evaluate the information to consider a research collaboration, or to evaluate the information to consider the prospect of a license being granted, or whatever the case might be, or to undertake some testing of some material, or whatever the case might be. Using it consistently with that purpose is fine. Using it for some other purpose is prohibited. No surprises there. But there's always some exceptions, of course. You can't have obligations of confidentiality in relation to certain things. For example, you might already know something. If you already know it, then you can't, and you have no obligations of confidentiality in relation to what you know, then you can't suddenly, by signing an agreement, now have obligations of confidentiality about something you already knew. So if a recipient can demonstrate that they already knew the information, then obviously they have no obligation of confidentiality about that. If information enters the public domain after the agreement is signed, then the whole world knows it. And if the whole world knows it, then the obligation of confidentiality has to cease. That makes sense. If the recipient develops the information independently, then they shouldn't be subject to the obligation of confidentiality. Now, you're probably thinking, if the recipient knows the information, how can they now independently develop it? Well, that is possible when you think about multinational companies or large pharmaceutical companies. One part of the organisation may be the recipient of information. Another part of the organisation can be doing research in exactly the same area or exactly the same field. And without the benefit of having access to the confidential information, they independently develop the confidential information. It sounds like it's unlikely, but it's actually more likely than you think. All science rests on the shoulders of the science that preceded it, so it's not unusual to have people independently recreate science that others have created before them, and confidential information is in exactly the same category. Receiving information from somebody else without obligations of confidentiality. Obviously, that's another one. If you've got a legal obligation to disclose, if you've got an obligation to disclose to a regulator or to government or something like that, that's obviously another exception. How long should these obligations be? Should there be a fixed number of years? Should they be forever? What do you think?
Fixed period?
Fixed period?
It depends on what it is.
Why does it depend on what it is?
Because, like, you've got the Coke recipe that's confidential and stuff like that. And depending on something that's going to be patent, it's going to be in the public domain.
True.
Forever.
True. Yeah, that's exactly right. But of course, we have that previous exception that says if it enters the public domain, then the obligation
Yeah, so
ceases.
like eventually it might enter the public domain.
Exactly.
So there's no point having confidential agreement forever. It's going to be patented or not patented in 15, 20 years.
You're right, it does depend. And it depends because you can't say that necessarily because the elapse of a fixed number of years, that as a result of that, necessarily, something loses its confidential character. And you mentioned the recipe for Coke. Well, that's the
That's
textbook.
why it's never been patented, right?
Exactly. That's the textbook example. Textbook example of something that's been confidential for, I don't know, 100 plus years, or whatever the period is. It's certainly over 100 years. But of course, not everything is in that category. Not everything is a Coke recipe that people want to protect for over 100 years. But of course, if you were to say on all occasions the obligation of confidentiality lasts forever, that would be very onerous on the recipient, because it would mean that the recipient would have to forever have to keep checking. Do I already know this? Am I receiving something? Am I assuming obligations in relation to something that the other person thinks is unique, and which at the moment I think is unique as well, but actually I already know it, so I shouldn't be signing up to these obligations. And I shouldn't necessarily be burdened by having to prove that I already knew it. So in some cases, people take the view that if you have confidential information and you haven't protected it by a patent within a certain period of time, then the burden of having to keep going back and check and check whether you're subject to obligations in relation to things that you knew about 5 years ago, 10 years ago, 15 years ago, 20 years ago, you should be relieved from that. So there's a balance. In other words, both answers that people gave, a fixed number of years and potentially forever like Coke, you're both right. There are some occasions where it should be a fixed number of years and it shouldn't be any more than that, because people recognise that the burden that results in upon the recipient. In some industry sectors, it's very common to have a fixed number of years, and biotech is one of those sectors. So 5 years happens to be the number. 5 years is the number that most people regard as being pretty reasonable. If we're talking about a disclosure of technology in the biotech sector which is patentable, then 5 years is regarded as the right duration. After 5 years, all bets are off. But if we're now talking about something in the biotech sector that is not patentable, that 5-year convention doesn't really apply. Now it should be like the Coke recipe. If you're never going to patent it, how do you know whether you should keep it confidential for 5 years or 10 or 20?
So who determines the length of that confidentiality agreement? Is set into the confidentiality contract agreement?
It's put into the agreement, but it's normally not controversial. It's normally not controversial because people in biotech, people recognise 5 years is the right time. Nobody argues about it. If the subject of the disclosure is not patentable and it's biotech, then you might want to still have 5 years, or perhaps a little bit longer, 7 or 10 years, because the rate of change of science in biotech is so fast. The pace of change is so fast that it's very hard to justify as a principle that somebody should keep it confidential forever and ever. But having said that, that's not universally true. I mean, you can think, for example, of say a formulation. Formulation might be something that you'll never patent. And 5 years is not enough protection. It should be forever. In fact, Coke recipe is a formulation. So that's an example of something where the convention shouldn't apply. And that wouldn't be controversial because people would recognise that the character of the information suggests that 5 years is not enough, and it should be an obligation that lasts indefinitely until it enters the public domain. Then in other fields of science, going beyond biotech, in other fields of science, there isn't really a convention of a fixed duration. It's more usual in other fields of science to say it's the obligations of confidentiality continue until the information enters the public domain. So if that's 6 months, that's 6 months. If that's 6 years, that's 6 years. If that's 60 years, then it's 60 years. It's until it enters the public domain. So it's an important issue to appreciate, but it's not always controversial. In fact, it's rarely controversial. People tend not to argue about this. But it's an important thing to have an understanding of, so that you don't agree to keeping something confidential, for example, for 2 years. That would not be acceptable. Common terms: if somebody wants to disclose, if the recipient wants to disclose your confidential information, they can't unless they get your permission. So, would you give permission to your information being disclosed? there something you want to see before you would give permission? And it could be that the recipient has quite legitimate reasons to disclose your confidential information. They might, for example, need to provide it to a consultant to help them with the evaluation that they're undertaking in relation to your information. Or they might need to give it to one of their affiliated companies in another country, or whatever the case might be. Or there's a collaboration involved and they need to share it with their collaborator, or whatever the case might be. There could be lots of reasons why your confidential information needs to be shared. But it can't be shared unless you permit it. And you shouldn't permit it unless the person to whom it's proposed that a disclosure be made to enters into another confidentiality agreement with you. Does that make sense? Why would you want anyone else to have access to your information on a non-confidential basis? If it's important enough when you give it to the first recipient to require that recipient to have obligations of confidentiality to you, then obviously it must follow that it's important enough that they shouldn't disclose it to somebody unless that person has obligations of confidentiality to you as well. So that's not rocket science, but it does tend to be controversial sometimes because people seem to sometimes think that, well, yes, I've got your confidential information, but I need to disclose it to my affiliate. And it's enough that I have obligations of confidentiality to you, and it's enough that they have obligations of confidentiality to me. Do you think that's enough? Does it sound like it's enough? This is one of the controversies from time to time. The answer is it's not enough. But as I say, sometimes it's controversial. What about things that are disclosed not in writing, that are disclosed by word of mouth, disclosed in a meeting, for example? Not disclosed by email or by an attachment, but disclosed in a meeting. Of course, the trouble with that is that there could be some controversy as to what was disclosed. There's nothing documentary that records what the disclosure was. So how do you demonstrate, or how do you prove that somebody has obligations of confidentiality in relation to what was told in their meeting? Especially if later they have a different recollection of what the meeting is and they assert that they don't have obligations of confidentiality. That's what the risk is. How do you manage that risk? Well, when you manage that risk, normally you'd say in the confidentiality agreement that there are no obligations of confidentiality in relation to things disclosed orally, except to the extent to which it's confirmed in writing within a period of time, like a month. So in other words, if you have a meeting, you make a disclosure of something orally, you've got a month to then put it in writing. And it's what you put in writing that is the subject of the obligations of confidentiality, not what was said. So if you leave something out, if you disclose something orally that you don't put in writing, there's no obligation of confidentiality about that. And this is both in the interests of both ourselves as well as the recipient. It's important for both because as a discloser, we don't want there to be any disagreement about what the subject matter of the disclosures were and what the obligations of confidentiality are about. We don't want there to be any disagreement about that. So it's in our interest to make sure that there's a record of that. And similarly with the recipient. They don't want there to be any dispute as well, subject to someone asserting that they've got obligations of confidentiality in relation to something that they can assert without any documentary proof. So it's in the interest of both that occurs. Now this doesn't mean that the agreement's going to solve the problem. The problem is only going to be solved by the discipline of ensuring that after any oral disclosure, in a phone call, at a meeting, even casually, over a drink, after a conference, where you've presented a paper. If it's confidential, put it in writing. And send them that. And that's then a record of what's subject to obligations of confidentiality. And that's very, very important. How are we going for time? I'm okay? You have to forgive me, I'll just keep talking unless somebody gives me a signal. Anthony's got the job of giving me a signal, trying to work out whether proportionally the time I'm taking up, there's a relationship to the number of slides I'm using up, and if it becomes disproportional, he's meant to tell me. So.
You've got about 40 minutes, Phil.
Okay, thanks, Brett. Just give me a wave if that proportionality is not working out. Right? To finish things off very quickly, obviously at the end, information's got to be returned at the end of whatever the relationship is that's being explored. But then again, do you return everything? Or do you keep a copy? If you don't keep a copy, how can you prove later what you had obligations of confidentiality about? So you never return everything. You have to keep a copy of everything so that you can, if the need arises later, so that you can demonstrate what it was were the boundaries of your obligations of confidentiality, what you were obliged to keep confidential, by what's missing, what you weren't. So that's pretty important. One of the controversial things in the confidentiality agreement, again, these things ought not to be controversial, but regrettably they are from time to time, and that is when you're dealing with people in other countries, as you often do, whose law is going to govern the agreement? Is it going to be the law of Queensland or is it going to be the law of Texas? Sorry? Delaware. It's controversial because, of course, the Americans, are there any Americans here?
Not open season.
Not open season. No. We won't say anything bad about Americans. We won't say anything bad about them. Okay, we widen it to everyone. Look, whether they're European, whether they're American, they will always have a preference for the governing law to be their own country. For people who so rarely deal with Australia, and Australia being a country that's furthest away from everywhere else on the planet, it's very hard for them to conceive being subject to the laws of another country. So if we say that we're subject to the laws of Queensland, it's a very hard thing to ask another party to do. And it's very easy for us to understand that when we think, would we submit ourselves in a confidentiality agreement to be governed by the law of Chile? And immediately, you're not necessarily comfortable about that, are you? You don't know what the law of Chile is. It's another language. It's on the other side of the planet. Do they regulate things in a way that is similar to our own expectations? Or do they regulate things in a way that is so different that we don't really know what we're agreeing to if we sign up to being bound by the laws of Chile? This is how Americans think. This is how Germans think. This is how Scandinavians think. And therefore, the issue becomes controversial if one party says it's got to be the law of my country, and here we say it's got to be the law of ours. When it comes to a confidentiality agreement, I'll say something that might surprise you. We should always agree to the governing law being the law of the other party. Now, that's not because we kowtow to people in other countries. It's because if we're disclosing information to somebody else, it's not going to be helpful for us to sue them here in Australia. They're not located here. So if we want to sue an American company, for example, in Queensland, we sue them in Queensland, we succeed, and then we have to go over to the United States and we have to do it all over again. So what's the point doing it here to begin with if you've got to go to the US and do it all over again? You might as well only do it once by going to the US to begin with. So the rule is, the governing law should be that of the recipient. If we're disclosing, the recipient's country should be. And that issue therefore becomes less controversial. So let's talk about material transfer agreements. Very similar to a confidentiality agreement, almost everything we've said applies equally to a material transfer agreement. But the additional thing that's going on now for material transfer agreement is there's something tangible being transferred. Possession of that is being transferred to another person. And again, they're getting something that is unique or something that is not freely available elsewhere, because if it was, they'd be able to get it. And so not dissimilar issues that we've been talking about start to come into operation. But there's obviously additional issues that need to be thought through. Possession of the material. In the same way as we don't want the recipient to disclose to somebody else our confidential information, we also don't want the recipient of biological material to go and hand over that biological material to another person, or any sort of material that we might provide. We want the material to be secure so that people who are not authorised don't have access to it. We want to regulate what people can do with the material. Are there particular experiments that they're going to do? Is there a particular analysis that they're going to undertake, or a particular evaluation that they're going to undertake? And that needs to be identified in the material transfer agreement, and they should not do anything else. Because of course the risk is if they do, and they create new IP, and they own that new IP, the issue that's going to arise is, are we going to be prejudiced in our ability, because we now have the IP, our IP fragmented, with somebody else owning a critical piece of it, of the IP that's available or relates to our project. Obviously, there's regulation of material related to use in animals or human use, compliance with ethical codes. People who provide materials don't want to be responsible for things that go wrong with the use of the material, where the recipient should be aware of how to handle materials. So if you're handing over possession of material that's toxic or infectious, then obviously the person who's receiving that should know how to deal with something of that character. And therefore, as a provider, you don't want to have to be liable for that. Ownership of new material is one of the issues that needs to be navigated in material transfer agreement. If it's progeny of that material, if it's a derivative of that material, if it's a modified derivative or an unmodified derivative of that material, who's going to own that? Or more broadly, if there's new IP created, who's going to own that? Is it legitimate, for example, for me to say, I'm handing over my material to you, if you create new IP with my material, I must own it, and you transfer ownership of it to me. Is that reasonable? What do you think? I only ask you the hard questions. That's what asking an easy question. What do you think? Is that fair? Do you think that's fair? It's not fair? It doesn't sound fair. Might there be some circumstances where it is fair? Example?
Here's a good example. This is one that I work with. We work with samples that are donated from donors from a hospital source, and we have to deal with sending. What happens when people ask us for access to that material? What are they entitled to? Are they allowed to have the whole tissue? Are they allowed to have the cells? Are they allowed to have the data source of the genetic code? Are they allowed to have protein from it, or RNA? It's those sorts of things that we have to decide, and we deal with them on a case-by-case basis.
This is when you're receiving the tissue or when you're giving it?
When you're giving tissue.
When you're giving it?
It works reciprocally.
All of those things. It's a valuable resource, and there could be very important commercial issues at stake, so it needs to be considered. Look, as unfair as it sounds, there are some circumstances where it would not be unreasonable to say, I'm only prepared to give you my material if you assign to me any new IP that you create. And if that doesn't work, and you also say, and if that doesn't work for you, I understand, that's okay. But I won't give you my material. So think about it. If we've got a project with some very valuable IP and very strong commercialisation horizons, very high expectations of doing good things with whatever it is that we've got, why would we prejudice that by handing over material to every man and his dog? I can think of one project where I think there were 34 material transfer agreements that needed to be considered, and their implications considered, to work out what the real value of this was. Where you have the prospect of all these other people now going off doing research, creating new IP that we had our own capability to create, but now because we didn't and somebody else did, they own a critical piece of the IP puzzle. And so does somebody else, and so does somebody else, and so does somebody else. And so our prospect of doing something good with whatever it is that we've got is now diminished. Because we don't own those bits of IP that are now set in various other places. People who may be unwilling to now give us rights over that IP. Or they may be willing to give us rights, but the price that they want is too high. They just want something that's disproportionately unfair. And unfortunately, what I'm postulating there is not exactly uncommon. So in other words, what I'm suggesting is you need to sometimes consider whether it's appropriate to hand over material to somebody else. Now I know that there are conventions that if you publish, you have to hand over material for research purposes to somebody else. I know that that's so. But that doesn't mean necessarily that you do things that now encumber you, or roadblock in front of you, in relation to the positive things to be achieved by the IP that's created. So these issues need to be considered and thought through. So they get different answers, but sometimes that's how it is. Let's pick the reverse. Now we have a company that has the material that you want. And most companies that hand over material to research organisations are prepared to do that and not necessarily argue about the ownership of IP, but they'll want to protect their rights in some way. They may want to have, for example, rights, a non-exclusive licence from day one in relation to the IP you create. They may want to have the ability to negotiate an exclusive licence in relation to the IP that you create. And from time to time, some companies will say, I'm not going to give you the material unless you assign the IP to me. Now, that does sound unfair, and very often it is unfair, because if it's the innovation of the recipient that's creating the new IP, for that to be transferred, the ownership of that to be transferred to a company for nothing, without any compensation, financial compensation, or any acknowledgement or reward. Am I going okay? Yep. Okay. I'm looking at your watch. Sounds unfair. But now look at it from the company's point of view. From their point of view, why will they do something to prejudice their position? So all I'm making you aware of by these comments is that there isn't an automatic answer to these issues. You will get different answers at different times. And on each occasion, it's a question of balancing these things. The company that you're wanting some material from may not be unreasonable in demanding some of these things. What needs to be decided is, are you really prepared to be encumbered by some of these things that a company might want? And maybe you shouldn't be encumbered. Maybe instead what you should do is think about some alternative material that you can get from somebody else that isn't encumbered in this way. So sometimes these things arise, and as I say, they're not necessarily being unreasonable when they're demanding this. It's just the commercial reality. They're not going to do something that is prejudicial to their own interests, just as you should not do anything that's prejudicial to your own interests. Somewhere along the line you've got to balance. When you can't balance, you've got to consider alternatives. These issues don't necessarily arise when we're talking about handing over material to colleagues as a service to the scientific community. These issues just simply don't arise. When we're doing that, the issues of ownership of IP are not as important. You hand it over, usually without these sorts of restrictions. If they create some new IP, then they create some new IP. The trouble is, though, not every material can easily be in this category, even when you are handing it over to another university or another research organisation. You need to give consideration to these issues. Where there are commercial considerations, you might need to decide, where should ownership of IP rest? Should it be us? Should it be with them? Should it be joint? In other words, is there really more going on here than just the transfer of material? Is there what's really going on here? It might be a collaboration. And a collaboration agreement now needs to regulate the IP position, respectively, of the two joint owners. And as between two research organisations, joint ownership is not necessarily a bad thing, but we're going to talk about that in a bit more detail later on. If we have the capability to produce the new IP that is equal to the recipient's capability to produce the new IP, then we may be prejudiced. If they create new IP that now creates some obstacle to our own commercialisation objectives. If they have a capability that we do not, or they have a skill that we do not, or they have access to something that we do not, so that they have the ability to create new IP which we do not have, then understandably they're not going to be willing to do anything unless they own the new IP. And if that's what their perspective is, and it's a reasonable perspective, then you work out some way of managing everyone's interests. So unfortunately, a material transfer agreement, because it deals with all of these sorts of issues, is never quite as straightforward as a confidentiality agreement, which most of the time confidentiality agreements will not be controversial and they can being signed. Most of the time, material transfer agreements are as well, when the issues of new IP are not relevant to what's going on. But when issues of new IP are relevant, material transfer agreements need to be very carefully thought through. And all these issues need to be considered. Sometimes there is a bit of negotiation of the terms of those sorts of agreements that comes about. So let's move on and talk about joint ownership of IP. We're going to talk about how it arises, how it's regulated in different countries. We're going to only talk about copyright, confidential information and patents. We're going to consider the implications of the joint owners of two research organisations and the implications where a joint owner is a research organisation and a company. So how does it arise? Well, it could arise because you've got a contract, like a collaboration agreement, that says IP that comes out of this collaboration is going to be jointly owned. Or it could arise because there's a collaboration where there's no agreement. If there's a collaboration taking place and IP is created jointly by the staff of two collaborators, then obviously those two collaborators are going to be joint owners. You hand over biological material to somebody, there is the prospect of joint ownership arising as well. If you're a student working on something as part of a team at a university, joint ownership can arise there as well, because something could be created jointly by a student and a supervisor, or a student and one of the other members of the research team that's an employee of the university. So obviously, joint ownership can arise there. In a collaboration, just to recap, two employees employed by two different employers, joint ownership is going to arise. That's the very simple case. Joint ownership is perceived to be something that is positive. When you collaborate, you jointly do things. You jointly share the benefits, you jointly have the burdens, and it makes people feel warm and glowing in their tummies to think about sharing. And so they automatically think about sharing the ownership of IP as well. Unfortunately, the shared ownership of IP is not necessarily a good thing. We need to be aware of the implications of joint ownership not just in one country but in other countries as well. Not just because we deal with collaborating with people in other countries. That's not the only reason. Even if you were dealing with a collaborator in Australia, so two Australian universities collaborate, when they create some IP that they jointly own, the US patent doesn't exist in Australia. It only exists in the US, and it is subject to US laws. A jointly owned patent in Japan is subject to Japanese laws. A jointly owned patent in Finland is subject to the law of Finland. The law of Australia does not apply when you've got a patent that we have to deal with in another country. So laws of that country will apply. So even between two collaborators in Australia, we need to know what the respective rights of the two joint owners are in relation to their jointly owned property that exists in the US, in Japan, in Finland, or whatever the case may be. Not just because we're dealing with collaborators in other countries, but because our IP can exist in other countries. And the other point to make before we get into some of the other slides is to say what we're going to talk about is what the position is when the parties don't agree what their joint ownership relationship, how their joint ownership relationship works. When they do agree and they record in writing how their joint ownership relationship works, then that's what will prevail over the domestic laws of any country. But where they fail to do that, then the laws in that country will apply. And the trouble is, it is more common to ignore these issues, just simply say in a collaboration agreement, we'll be joint owners, full stop, and not address the issues that need to be addressed. And so more likely than not, the agreement has not addressed the issues of joint ownership, and we are subject to the laws that operate in other countries. Sometimes that's intentional, and when it's intentional, that's okay. But very often it's not intentional, it's purely accidental. So let's talk about copyright first. And copyright could be software, it could be anything else. It could be a literary work, it could be an artistic work, whatever. It could be joint ownership or it could be a collaboration agreement. Three questions we need to ask. Can one joint owner transfer their part of the jointly owned copyright to somebody else? Do they need consent? If so. Can one joint owner grant a license without the consent of the other? Can one joint owner exploit the copyright, like software, without the consent of the other joint owner? These are the three questions that, regrettably, that don't get addressed. In relation to copyright, it's not unlike a partnership. So let's say you and I are dentists in a dental practice. If I said to you, well, I've got a patient coming in on tomorrow afternoon, and fees that this patient will pay tomorrow afternoon, I'll keep those. We won't put that into the partnership accounts. I'll just keep that pocketed myself. That's okay with you, isn't it? Obviously, it's not okay, is it? Well, that's what the situation is in relation to copyright. In relation to a partnership, one partner cannot, by themselves, take the benefit of the partnership. By its very fundamental nature, a partnership is benefits have to be exercised jointly, be taken jointly. And that's what the situation is in relation to copyright. Pardon me for jumping a few slides. I'm keeping an eye on the clock, and I think we need to put the foot on the accelerator a bit. Let's ask these three questions in these three countries. Can one joint owner assign its share of the copyright without the consent of the other joint owner? In Australia, the answer is no. In the UK and the US, the answer is yes. Can one joint owner grant a license over the copyright without the consent of the other joint owner? The answer is no, in all three countries. The US does permit a non-exclusive license to be granted without consent. But if it's an exclusive license, the answer is no in all three countries. Can one joint owner exploit without consent? And the answer is no in Australia and the UK, and it's yes in the United States. So we have a complete lack of harmonisation on this issue. But when you try to discern a principle from all of this, the principle basically is, not unlike, as I say, any partnership for a dental practice. The joint owners are meant to, subject to some of the exceptions that you see here, joint owners are meant to exercise the benefits of jointly owned copyright together, not separately. So let's consider what the implications of that are. Let's say we have a collaboration agreement with a company, and what's going to pop out is software. If the company goes off and commercialises the software, it would be in breach of its agreement with its collaborator, because it's not meant to exploit unless it's done with consent, or unless it's done together. To give you a more basic example, let's say we have joint authors of a book. Can one author go and publish it, grant a license to a publisher to publish it? The answer is no. They have to do that together. They cannot do that separately. So in other words, truly we have the two joint owners mangled to one another. Neither can really do anything without the consent of the other. As a general rule, as I say, you can see some exceptions. One exception being in the UK and the US, you can assign your share to somebody else without consent. That's actually not how most countries deal with it, but the UK and the US simply decided that's how they would choose to deal with it. Most countries are more aligned with Australia. In fact, most countries in the world are more aligned with Australia on all three questions. The other exception, of course, being in the US, a non-exclusive license you can grant without consent, and you can exploit without consent. As you said, there's a lack of consistency. What this really highlights is that there really is a need to address these three questions in the collaboration agreement. You can't just simply say, we'll be joint owners, and then disregard what the answers to these three questions are. There are three critical questions that need to be answered. Let's move on. Confidential information, let's say, is not unlike copyright, but we have to move on because of the time. Right? Let's ask these three questions now in relation to patents. Can one joint owner exploit, without the consent of the other joint owner, exploit the patent and pay no royalty? The answer is yes, pretty much all over the world. There are a few countries here and there where the answer is no. South Africa is one. You may think that's not important, but if you had a mineral exploration technology, that's really important, because South Africa is a location of mineral exploration technology. So that's the answer to that question. In most countries in the world, pretty much universally, with a few exceptions, one person who is a joint owner of a patent can exploit without the consent of the other and have no obligation to pay royalties to the other.
In the case where they do have an obligation to pay a royalty, how is that royalty concerned?
Ask me to come back another day.
Yeah. Difficult? Okay, so.
That takes a long time to answer that question. Let's ask the second question. Can one joint owner assign their jointly owned patent without the consent of the other? And in some countries the answer is yes. United States, Canada, Malaysia, France. In most other countries the answer is no. Can one joint owner grant a license of the patent without the consent of the other? The answer is yes in the United States. The answer is no in most other countries. China again has got, the answer is yes if it's not exclusive, but the answer is no if it's exclusive. But in the US the answer is yes, in other countries the answer as a rule is no. So let's think through what the implications of that are. Let's not worry about the slides. Let's just work through the implications. Let's say we have two research organisations, two universities that are collaborators, and they said we'll jointly own the IP that comes out of their collaboration. What's the result? The result is that each can exploit the patent without the consent of the other. Let's not worry about assignment because its practical importance is very small. Neither can grant a license without the consent of the other. Now let's go to another level and look more pragmatically. Even though the two university joint owners are able to exploit without the consent of the other, will they do that? The answer is no, they're not. They're universities. They're never going to get sanctioned to become manufacturers and distributors of products. If we're talking about a drug, they're not going to pay the $500 to $800 million that it takes to go through the regulatory pathway and clinical trials to get a drug onto the marketplace. They're not going to build a factory to make drugs, and they're not going to have worldwide distribution channels. The universities don't do that. So that's not going to happen. So are universities going to become exploiters of the IP? As a rule, the answer is no. Neither of them will do that. And neither can grant a license without the consent of the other. So the situation is not unlike copyright. Neither can do anything without the cooperation of the other. So joint ownership between two universities where these issues are not completely addressed is not necessarily the end of the world, is it? It's two universities, they share the same perspective on life and they can think about issues in a similar way. If a commercialisation opportunity arose, then they could address that and you could have confidence that they will work through the issues and come up with an answer to deal with those issues and work out how to together commercialise that. Normally that's done by one granting a licence to the other joint owner. So two universities being joint owners and leaving these issues unaddressed is not necessarily the end of the world. But now let's talk about a university and a company and ask the same questions again. Let's say you might, again, collaboration or just simply a funding agreement from a company where they provide money for research, and UIP pops out. Joint ownership was agreed at the outset because that made people feel warm and fuzzy and good inside. What's the result when they're joint owners of a patent? Can one joint owner exploit the IP without the consent of the other and pay no royalties? The answer is yes, they can. So therefore the company can exploit and pay no royalties to the university. Can the university exploit? The answer is yes as a matter of law, but no as a matter of practicality. They can't. So the result is the company exploits, makes money, but pays no royalty to the university. Now, so the university says, well, this isn't it's a bit unfair. I need to get some financial return on this as well. That's what the fair thing would be. So I want to grant a license to this company. So you're the university. I've come to you. Sorry, you're the company, and I'm the university, and I've come to you. And I've said, so you're making a lot of money out of this. And I want to grant a license to this other company over here so that I can earn some royalties. So you'll give me permission to give them a license, won't you? Oh, why?
I'm making money, so I'm going to have another company.
Yeah, exactly. He's not going to give me permission to create a competitor. Why would he do that? It's not in his interest to do that. So, if you've agreed on joint ownership between a university and a company, one joint owner is making money, which is the company. They're exploiting. Is the other joint owner making any money? No, they're not. So the university makes zero. The end result is that joint ownership is not necessarily the sharing model with mutuality that was presumed at the beginning, was it? People agreed on joint ownership, assuming that joint ownership means an equal relationship, a mutual relationship, equal benefits, equal burdens. That's what joint communicates. And therefore the expectation is equal treatment, everything is mutual, but that's not so. Joint ownership does not lead to that. 10 minutes to go. Joint ownership doesn't lead to that. And of course, it's not just the university that we're talking about. We're talking about any joint owners that have the characteristics that we talked about. Now, the characteristics are, one joint owner has the capability to exploit and the other joint owner does not. So we're not just talking about universities, we're also talking about any sort of research organisation. We could be talking about government, we could be talking about startup companies, we could be talking about SMEs. We could even be talking about large companies that in the whole scheme of things are not necessarily in a position to compete with multinational. So joint ownership and its downsides are not necessarily restricted to universities, they're restricted to any joint owner where those characteristics are present. Now, if those characteristics were present and dealt with in the agreement, the collaboration agreement, then that's what would regulate their relationship. And what this really highlights is therefore the need to regulate that relationship. All these slides pretty much take us through that reasoning that we've been going through the last 10 minutes. What the message is that you don't agree to joint ownership automatically. It needs to be a very intentional decision to agree to joint ownership because on that occasion, in relation to that relationship, that deal is the right thing to do. And then the second question is, you need to consider, do you leave it there saying only, we will be joint owners and saying nothing else? Or do you go one step further and say, we also now need to regulate our relationship as joint owners and regulate what we can and what we can't do? They're the critical questions that need to be asked. And sometimes the right answer is to say, we'll be joint owners and there's nothing else to do, nothing else to say. That might be okay if it's two universities. It's not going to be okay in any other case. Even when it's two universities, it's not universally okay. Because sometimes what comes out of what's expected to come out of the collaboration in relation to a project that's very mature or a project that has a high commercialisation horizons or expectations, and the right thing to do is to manage these issues right at the very front. Just as you sometimes need to manage these issues right at the front end of a material transfer agreement. Is that okay? All right. So, students and IP. Students create IP. There is a law that says that an employer owns the IP created by an employee in the course of employment. So all the IP that's created by QUT staff is owned by QUT. Nothing controversial about that. Unless you want to talk about recent litigation in recent years in UWA and Grey, which we can if you want to, but we'll park that for the moment. The starting point is QUT owns the IP created by its staff, by its employees. Students are not employees. So therefore students are not subject to that general legal principle. A student that creates IP owns the IP that they create. If they create IP solely, the student owns that IP. the student creates IP jointly with staff of the university. There's a research team that's composed of both students and staff. Then the IP is jointly owned by the student and the university. So joint ownership is a very likely possibility whenever students are involved in research. So now we need to consider the implications of joint ownership. So remember we said, if we're talking about a patent, for example, one joint owner can't exploit, or can exploit, without the consent of the other, but the student can't exploit. Not as an individual, they can't. The university can't exploit, pragmatically. Neither can grant a license without the consent of the other. So a student can veto commercialisation. Can you see how this will be intolerable for a university? If a university is, for example, subject to obligations, contractual obligations to somebody who's providing a bucket of money, and there's a student who is a joint owner of IP, they can veto what can happen to the IP. You can see that the university would be subject to lots of legal exposures under that contract, because under that contract it would be stating that it would deliver on certain things in relation to the IP. And if the university doesn't own 100% of the IP, then its ability to deliver on those obligations in relation to the IP is affected. So as soon as you have a joint owner who's a student, or a student that is a sole owner of a critical bit of IP, immediately start to give rise to issues concerning the university's ability to meet its contractual obligations, which therefore means that somehow we need to address that issue. Universities need to promise that they own the IP. And if they don't own the IP, they're in breach of those promises. And again, they're subject to exposures and liabilities and prospect of getting sued. I think I've got something like that going on right at the moment. I only found out about it a couple of days ago. We did a deal about 3 months ago to an American company. My client was an Australian company, and there wasn't a student involved, but it's the same principle. This is what I'll tell you. And the company had obtained a license of IP from an Australian university, not in Brisbane, I might add. So you have to pick one of 45 rather than one of 3. The company obtained a license from the university. Now, when we did the deal, we all understood that this was the only IP that we needed to on-license to the American company. So we licensed the patent and its improvements and everything else. And what was disclosed to the American company as what was being licensed was disclosed as being a great big body of IP. Now what's emerged 3 months later is that there was in fact a parcel of IP that was created by the university independently of the license, off to the side, and I think there were some students involved, but the students had done assignments, so that's not really the issue. The issue is, there was a parcel of IP sitting off on the side that we licensed to the American company because the company thought it owned it. Turns out that it doesn't. It's owned by the university. Now, what's going on now is that the university is willing to transfer ownership of this relatively minor, almost inconsequential part of IP, but they see an opportunity to demonstrate some unreasonableness, and they've embraced that opportunity. And that's creating a lot of anxiety. And this company was once a university company. It's now a much more mature company, but it was originally spun out of that university. The problem was that not all the IP was captured. Because not all the IP was captured, my client is now having threats being made against it. It's being intimidated to solve this because it's in breach of the deal that was made. And the deal involved a lot of money. Now, unmaking the deal is not an option. The deal is made. People have high expectations of all the benefits that each accrue as a result of this deal. So it's a problem that must be solved. So, not capturing that small bit of IP has now created an awful lot of anxiety, the threat of litigation, and certainly massive disputes. And these are the sorts of things that can happen when a university deals with IP that it believes it owns when it doesn't. Well, not just in relation to students, but in relation to anything. I mean, having, for example, a piece of IP jointly owned with another collaborator that emerges after the deal, exactly the same problem. But students, exactly the same issue arises. There's a critical component of IP not owned by the university does a deal with that IP. Now, the purpose of doing a deal is, of course, not just to make money, it's to get the outcomes of research out into the community. That's what commercialisation is really all about. It's how outcomes of research do beneficial things in the community is by doing deals that enable people to put products out there or those things that are beneficial out there. But you don't want to have to run these sorts of risks and be sued if these are the things that happen. The solution is therefore that students are asked to sign deeds of assignment. And it's extremely important, given that we're talking about a commercial transaction between a student and the university in which they enroll, it's extremely important that the document be extremely fair. Students must be treated fairly. There should not, or there must not be duress. There must not be intimidation. There must not be any of those things. Any of those things could affect the validity of the document. So in other words, just simply having an assignment doesn't solve the problem. If the assignment is tainted by the possibility of duress, or by the possibility of undue influence, or the possibility of intimidation. You know, back in the old days, what used to happen, Tim? Well, you don't get your PhD. Back in the old, have I got time for a story? 2 minutes. It's really quickly a story. I got a phone call from a postgraduate at one of the University of California campuses, who rings me out of the blue, Australian, and she explained she was a postdoc at this one of these UC campuses, and I own the IP, this IP, and I don't give you permission to sell it. Right. Calmed her down, found out what the story was. The story was that she had done her PhD at this Australian university, and she was an inventor of a critical patent. Never heard of her, never knew that she existed. Why didn't we know that she existed? Because her name was not on the patent as an inventor, even though she was a critical inventor, a critical part of the parcel of IP that we were doing a deal. And we were doing a very big deal involving some tens of millions of dollars. And to get a phone call a few days before the deal is due to be signed, saying something like that can be put you off your balance a bit. Anyway, what emerged was that there'd been a great falling out between her and her supervisor. She was erased from history. Everyone in the lab just simply knew, like Voldemort, she has the name that must not be mentioned. Everyone knew never to mention her name. We would all speculate what the reasons were for the falling out of the relationship. Nevertheless, that's what happened. And she was erased from history. Her name was not on the patent. She was never mentioned as being a contributor in this patent. Whereas, in fact, she was one of the major contributors and a major inventor on a critical patent. How did she find out about this? She found out, of course, because her friends still in the lab rang her and made her aware of it. The deal was not signed a few days later. Signed a few weeks later. We had to work out a deal with her for her to formally assign her IP to the university. If the deal had been done, the university would have been sued for a very large amount of money, given the extent of the defect in the title to the IP that was represented by not having taken care of that piece of IP that she had contributed. Moral of the story is, you can't roadblock commercialisation. You have to facilitate it, and part of that facilitation is that from time to time, students need to be asked to assign the IP. But as I said, there need to be absolutely fair assignments, no duress, no intimidation, none of that. Which means students need to be given a choice. If they don't want to assign the IP, then they should be taken off the project and they should be given an alternative project that has equal merit, equal academic and scientific merit, and they need to be excluded from the project that either has the contractual obligations or has the commercialisation horizons. The student can't be forced to assign IP. It needs to be a decision that's made up front. If a student does not want to assign IP, they've got to be excluded from the project. They must be offered something else that has equal merit. But if they do agree to assign the IP, then the document has to be extremely fair. They need to be treated as a member of staff in relation to the sharing of commercialisation benefits. So when commercialisation revenue comes in, the commercialisation of the IP, that has to be distributed in accordance with the university's policies, giving splits of that revenue to all the people who've made a contribution to that IP, and the students need to be treated in exactly the same way as a member of staff in relation to that. Students have to publish. That has to be something that is almost cast in stone, is the ability to do that. There must not be any impediment to having a thesis examined. That's just absolutely sinful for anything like that to happen. But of course, they assign IP other than copyright and the thesis, student always retains that. And very importantly, students need independent legal advice. So there's absolutely no doubt that they have signed the document voluntarily and they've signed the document without duress and without consideration. But, as I say, when asked to sign a deed of assignment, it's important that it be done. And if it can't be done, you've got to find something else to do. Can't be involved in a project that has contractual obligations or has commercialisation clauses. But it must be fair.
The supervisor has to provide the other option.
Well, it's the responsibility of the university to provide that option, yeah. But yeah, the supervisors
But it
obviously.
doesn't mean you can't study at QT.
Oh, no. But there really is an obligation to offer another project.
Yeah.
That, for example, as I say, equal scientific merit, but doesn't have any contractual obligation to other people, and doesn't have the same commercialisation horizon as this project might have.
Exactly.
So it's not every occasion that every project that students involved in, there's a need for an assignment. That's not necessarily the case. Maybe some. Questions? No? Okay. Thank you. One?
I've got a question, sorry. On confidentiality agreements, especially in the, I guess, the early stages of maybe collaborating with a partner, and you've got some IP and maybe they've got some IP, a common tactic is to put forward a mutual NDA, mutual non-disclosure agreement. What do you see as being the downfalls of a mutual NDA? A positive that I've come across is quite simply, it alleviates, it's not a one-way street, it basically allows to have an open conversation both ways, and we can kind of, assess whether, product A matches with product B in order to progress to the commercial stage.
Most confidentiality agreements are two-way or mutual, because there is information flow going in each direction. Not always the case, but it's not unusual for that to be the case, so it's just business as usual.
Yeah.
If there really truly is information flow going both ways, as I say, that's business as usual. All right? Thank you.
Well,